So I'll start off by introducing Richard. It gives me great pleasure to be able to introduce Richard. It's a real privilege to have him come to speak to us today. Richard is a partner at Norton Rose Fulbright. He's a partner in the banking department. He's been with the firm since 1975. I'll betray his age. And his practice focuses on banking, security, and insolvency. He advises on the financing of corporate transactions, restructurings and rescues, administrations, receiverships, and liquidations. He's a member of the City of London Law Society's Financial Law Committee. He's also a visiting professor at University College London. He has published extensively on banking, security, insolvency, and on contract. In addition to numerous articles and chapters in books, he's also the author of Taking Security, Law and Practice, which was recently published in a new edition, the third edition, 2013. He's the author of Proprietary Rights and Insolvency, published by OUP in 2010, and a very good recent book on the principles of contractual interpretation, published last year. So it's wonderful that he's agreed to come to speak to us today on the reform of secured transactions law, an area that he's been very closely involved with over the years. And I'll just hand over to him now.
Thanks very much. Good morning, everyone. I don't know whether you'll be able to hear me without the microphone. So if I move around and you can't hear me, just sort of wave and I'll come back here. My topic for this morning is the reform of secured transactions. I don't really like giving lectures. I'd much rather have a discussion. Now, with a group of this size, that's not easy. But let's see where we get to, because I want to see if I can get you to do a bit of talking as well. You'll get very bored with hearing me after an hour and a half. Let me just start with asking, just a show of hands. I want to get a feel for how many of you are common lawyers and how many of you are civil lawyers. So hands up the common lawyers. Okay, thank you. And hands up the civil lawyers. Okay, it's about 50-50 by the look of it. That's very good. What I want to do is to start off by just seeing if we can work out what if you were starting with a blank piece of paper, what a good law of secured transactions would look like. And then I want to compare where we get to with what we have in English law and see what are the good points and what are the bad points, with a view to seeing what needs to change. And then finally at the end, what I might do if we have a bit of time, which I'll try and make sure we do, is just to take you through the last 20 years of the way in which the reform process has stopped and started over that period, and see if we can discover why it's been such a tortuous process over these last 20 years. So I think the starting point is, what is a good law of security? And what I want to do is to break it down into three topics, because it seems to me that if you need to understand how secured transactions work, there are essentially three things which you need to work out. The first is, have I got a valid security interest, proprietary right by way of security? Have I got a valid proprietary right by way of security, which is effective in the insolvency of the debtor? Now, there may be situations in which there are moratoria or other bars on enforcement, but as a basic principle, have I got an interest which is recognised as being effective in an insolvency? That's my first concern. The second one is to work out whether the interest which I got is one which will take priority over anyone else who obtains a proprietary right over the asset concerned. And to the extent that I don't get priority, that I understand to whom I'm ranking, or over whom I'm ranking behind. So the second thing is priorities. And then the third one is enforcement, because security is not an end, it's a means to an end. I don't want a charge over a factory. What I want is cash to repay my loan. So the important thing that I must have is the ability to be able to turn my security into cash. And of course, the most important time at which I need to be able to do that is when the debtor is subject to some form of insolvency process. So I need to be comfortable that even in an insolvency process, I can enforce my security and get my money. So those are the three things which it seems to me are crucial to any secured transactions law. And so what I want to do is to look at each of those in turn and to ask you initially, and I hope that you'll be forthcoming with some comments, to ask you what you think is needed in relation to these three areas in order to have a secured transactions law which works in practice. Now, I'm assuming, and I think we need to assume for this purpose, that there is some social and economic utility in having a law of secured transactions. In other words, I think we have to take it for this purpose as a given that there is a good economic reason why one needs to be able to give creditors security. My experience over the last very many years, as Raphael has said, I started as an article clerk in 1975, but my experience since then has been that quite a lot of transactions would not have happened were it not for the ability to take security. And so I do see a real economic value in taking security. But let's put that question on one side. Let's assume that that is the case. And on the assumption that it's sensible to have a secure transactions system, the question then, I think, is what is the best form that that system should take? And we've had a lot of discussions over the last 20 years in the UK, and there have been a lot of discussions elsewhere of the utility of secured transactions law, how it can be changed in order to reflect better the way in which transactions are done. But what I want to do for the moment is start with a blank piece of paper. What makes a good law of security? So let's start with the first of those three limbs which I suggested secured transactions law is concerned with, which is I need to have a valid proprietary interest by way of security over the assets of the company concerned. And as a general principle, that right is enforceable in an insolvency. Now, you come from a lot of different backgrounds. Half of you approximately were common lawyers, half of you were civil lawyers. You will have experience of the way in which secured transactions law works in your jurisdiction. And based on that, what I want to do is to pick your brains. I want to know what you think would be a sensible way of allowing someone to take security over assets. Is it better, for instance, to have a system by which you have different types of security interest for each type of asset? So you have one system for land, another system for goods, another system for receivables and contract rights, another system for shares and securities of companies, those sorts of things. So should we have a series of particular types of security interest which reflect the nature of the underlying asset? Or is it better to have just one form of security interest which you can take over any type of asset? Now, just based on your knowledge and your experience, anyone out there prepared to give me a view on that? One system or a variety of different types? Anyone have a view?
One system.
Thank you, Sarah. One system. Okay.
Different systems.
Sorry? Just different systems. Okay, so let's come to why different systems.
Just for the reason you have just mentioned. So when we look into the essence of or in the nature of different types of assets, so there could be reasonable to have different registration requirements. For example, so I'm coming from a civil law country, where there's a huge difference between the types of different securities which you apply in respect to, for example, to real estate property or to shares or to IP rights. So because all of these type of assets are regulated differently and they have different statutory rules applied to them, then it just makes sense to, and because these security sections fall, it's not a primary but secondary application. So in civil law system, it's sometimes reasonable to make these secondary rules really linked to the primary rules, and then it will work in the whole system and will be more understandable.
So you have, for those, I don't know whether everybody could hear that, but the idea is that where you've got different types of assets with very different types of feature to them, and the rules relating to which are different, then it makes sense to have a security system which recognises that fact and creates different types of security interest over the different assets. Just for the moment, let me just let's park that and just look at the single system. Is there anyone else who would go for a single system rather than a series of different rules? Anyone go for a single system apart from Sarah Withington at the back there? I know. Please tell me why.
Because what you're trying to protect is the lender's interest, which isn't specific to the asset over which you securitize. What's important is the relationship between the debtor and the creditor, not the asset over which that is being secured. Right.
So the nature of a security interest is such that you're saying it doesn't really matter what the underlying asset is. You've got a security interest which should have certain common features, if you like. Whatever the asset is, it's taken over.
In a system with different types of regulation, some types might be more burdensome than others, and you shouldn't have a system that artificially makes certain asset classes more valuable as security, or certain asset classes leading to lower yields than others.
So the other point there, just for those who didn't catch all of that, is that if you have different types of system relating to different types of asset, the nature of things is it's going to be easier to take security over some types of asset than over others. And that creates sort of arbitrage, really, where it's more expensive to take security over some types of asset than over others. And is that a sensible thing to do?
I would also say that having one system would be beneficial for the purposes of having public information, because if I were to do a due diligence on a company and its assets, it would be easy to go to one simple registration to see all the assets that may be pledged or whatever, instead of having lots of different systems.
Yeah. So the system of information, transparency, registration, whatever you might call it, that benefits from having one system rather than a number of them.
So against the one system proposal, there's the error with thinking that one system fits all. And then what you have is that you wouldn't have systems that would go with economic and commercial development and innovations. And when you look at the conservative nature of our judges and you bring something that's not right there in the book, then you probably wouldn't be encouraging commercial. So I would say, let the commercial developments define the system of security you want to take. Have one system determine what sort of security you want to take. So I go with the other view that would rather have different systems with different transactions.
So one system matches all, covers all, wouldn't necessarily help. You're saying where there are changes in the way in which we do financing, and of course that happens all the time, as we know. And you think that it might be better if you have a variety of different types of system. excuse me, in order to deal with that. I mean, you could put it the other way around. You could say if you have just one system, it's easier to develop security over assets that haven't actually come into existence at the time you create the system. So I think you could play that both ways. Let me just have a show of hands. I think quite a lot of people might, and I'm certainly, I count myself amongst these. If you grow up in a system, you tend to understand its benefits if you're using it, and lawyers don't always like change. At least that's the view expressed about practicing lawyers by most academic lawyers, anyway. Whether that's true, maybe something we can come and talk about a bit later. But I just want to take the civil lawyers first of all amongst you, and just ask you whether you would rather have a variety of different types of security, as most civil law systems do, as you've described, or whether you would rather change that and just have the one system. So just the civil lawyers for the moment. Hands up those who like having a variety of different types of security interest. Okay, and hands up who would rather have one. There's a lot of don't knows. Okay, what about the common lawyers amongst you? How many of you like the idea of having one system? Okay, and how many, thank you, how many would rather have a variety of different types of system? Okay. There's quite a lot of variety of opinion there, which is interesting. And I find actually quite surprising, really, because my experience talking to my French partners, for instance. Are there any French lawyers here? Okay, I can talk about French law then without fear of retribution. The partner I spend most of my time talking to in our Paris office is actually an American, but nevertheless, he has very strong views on the subject, which is that if you're trying to take security in France in the way that you might try and take a debenture here, in other words, security over all the assets present and future of a company, you need, I don't know how many documents it is to do that, but certainly a very large number. And even then, you don't quite get there. And he certainly is of the view that it would be better to have just the one system. But what's interesting is that some of you would say, actually, there are advantages, and I can understand this, particularly if you've grown up in a system and got used to it. There are advantages in having just the one system. So we don't really have a view whether there should be one system or not. I think there are alternative views here. But I think let's just have a show of hands of everyone in the room and just see if we can get a balance one way or the other. Who would go for one system? Hands up. And who would go for more than one system? Hands up. Okay, I'm going to go with the one system, I think, because they're certainly the majority, vast majority, I would say, go for one system. But one can see that there are arguments to the contrary. And of course, what's interesting about this topic of reform is that we all have very different views on what is a good process of reform. Some people, and I'm sure I'm one of them, tend to think that what they think must be right, and that everyone else who takes a contrary view must be wrong. And of course, we're all a bit like that, aren't we? But we do need to realise that others have quite legitimate views on these areas. So what I'm going to give you today is a very biased view of what things should be, and you have to take it with a pinch of salt and decide whether or not you agree with it. So let's assume for the moment that we have one system of creation of security. I think the next question is how easy it should be to be able to create the security. And it seems to me that there are probably two ways of looking at this. One is to say that it should be possible to take security very easily over any asset, simply by the debtor and the creditor agreeing that the debtor should grant security to the creditor. That's one possibility. What's the concern about that, though, from the point of view of others who might be interested? If it were very easy to create security simply by an agreement between the debtor and the creditor to which no one else is a party and which no one else is aware of, what are the concerns about that? Would anyone have a concern about that?
No, because it's then for the other creditors, it's just very difficult to evaluate the risk.
So
they really need to know what securities are still there.
So other creditors out there would need to know what security has been created. Now, how would you do that?
Well, I guess the common thing is a register for registering security interests.
Right. Where are you from?
Germany.
Okay, I thought you might be. No, you don't have a registration system, do you?
Only for land.
No, only for land. But you don't have, if you like, a company's registry when you register security interest, do you? Now, the interesting thing is German lawyers that I've spoken to say, we have a perfectly good system of taking security. It works perfectly well. We don't need a register. And all these people, most notably Americans and British people who say we ought to have a register, are just talking out the back of their hats. What view do you take of that?
Well, yeah, what I just said, I think register, can have advantages.
Yep.
Exactly from other creditors.
So you would see an advantage of having a register. I mean, I suppose the other way of dealing with it, and this may be where your point about individual types of security interest comes in, if you actually have a system by which it's not possible to take a universal security interest over all assets, and therefore you have to go through various steps in order to create a particular security interest over particular types of asset, that makes it more difficult to take security, doesn't it? And it may be, depending on what the requirements are of the particular law concerned, it may be that the steps to be taken in order to create the security interest are sufficient to put third parties on notice of the creation of the security interest. So it seems to me that if you're going to have a system which makes it quite difficult to create security, because you've got to bring your security within a particular category relating to a particular type of asset, it may be that you can get by without a registration system because actually it's quite difficult to create security. But if, on the other hand, you have a security interest which allows you to create security very easily over all the assets of the debtor, then that of itself creates problems, doesn't it? It creates problems, as you said, for the other creditors of the company, and therefore we need to find some system by which we notify others of the existence of the security. And of course the most obvious system is a registration system. So we've got two things so far, I think. We've got a general consensus, which is not shared by everyone, that it's a good thing to have one system of security. And then we also have the idea that it would be problematical for the debtor and the creditor to be able to create security very easily without some form of notice to third parties, and so some form of registration system. And then I suppose the question is, what sort of registration system do you have? But I suppose before we get that, let's have another show of hands. Who is convinced by the idea that security interests ought in general to be registered at some central registry that third parties can search? Hands up who thinks that's a good thing. Okay, thank you. And anyone say no, it's not a good thing? Now, you say it's not a good thing. Is that because, well, explain why.
Well, again, it goes back to the nature of security. So for some, let's say like important assets, it could be beneficial for everyone to have a register, to be able to file documents, or just to give notice and to have a list of assets. But there are some type of assets like raw materials or products or ventures, which are essentially, it's not so easy to identify them and to file any kind of notice to the register. So this is one issue. Another issue that whenever you have a centralized register for all types of securities, it increases transactional costs, which could be not justified for certain types of securities.
I mean, that second point is an interesting one, I think, particularly because what you're saying is that actually, if you have a registration system, that can increase transaction costs. And I can see that in theory. I have to say that working in a system which has always required registration, the cost of the registration system is absolutely minuscule in comparison with the cost of putting the structure into place in the first place. So I can understand that if it were to be very expensive, then that would be an issue. But you can certainly, I think, have a registration system that does work perfectly well, which actually doesn't cost very much to run. So again, this is not a universal view, but the overwhelming view, I think, of most people is a registration system is useful. I suppose the next question is what you should register. Should you register everything, or should there be certain types of security interest which are not registrable? Many systems take the view that in general, and the English law certainly now takes this view after a long time of about 100 years of getting there, but it did get there eventually, to the view that every charge or mortgage created by a company requires registration, but not pledges. So in other words, if you have possession, you don't need to register. I suppose that's a reasonable view in the sense that the idea is that the creditor who's got a pledge will have possession, although not always physical possession of the asset being held. So there are issues at the boundaries as to how far the registration system should extend, but generally I think one would expect it to cover most types of security interest. What I think might be more controversial than the extent of the security is of the registration process. What might be more controversial, I don't know, we'll see in a minute, is what the effect of non-registration should be. What would you have the effect of non-registration to be? Would it be that the security interest is void? Would it be that the security interest would, let's say, rank behind a registered interest but still be valid? What punishment, if you like, would you accord to those people who did not register their charges? Does anyone have a view on that?
I would say I'll make it rank behind. I mean, I don't see why really the failure not to comply with the formality of registering would actually lead to your interest being declared void. But on the flip side, it is unfair to other people who are diligent enough to go and register that their interest being behind someone who did notify, but otherwise they might not have taken that same interest at the same level, or might have made alternative arrangements to ensure that they were a more secure creditor.
Right. So you would start off by saying actually it should be a priority point, but nothing more. But actually, towards the end, you were beginning to explain why it might be stronger than that.
I'd say that the first registrar should have priority over people who might have had their interests created beforehand,
right,
but failed to register. I think that would incentivise people to register.
Right.
It would protect early registrars from prejudice.
So you would make it a priority point. You would say that once you've registered, then you've got priority over any other registrable interest, and presumably then priority over someone who registers later. Okay. Would you go on, though, to say, or perhaps you wouldn't go on to say, that the security should be void generally?
No, I wouldn't go on to say that.
Right.
I would still say that...
You would just make it a priority point. Okay. Right, okay.
The very aim of the registration system is to protect third parties and notify third parties. So if there is any, if the security is not void, then what's the point of the registration? The very aim of this system is to notify third parties. So if it would not be valid void, then why?
So if you're going to protect the people whom you're trying to protect, if you don't make it void, you're not protecting them, you're saying? Yeah?
If you turn that around and say that because it's about notification, it shouldn't be void because it's protecting parties who don't know of the security. So if there are parties who know of the security, they should rank behind because they don't need the notification.
Right. I mean, so if they know about it already, then they should take subject to it. Okay.
But although in principle I agree with the idea of the priority issue, there is also the possibility that third parties are interested in knowing if there is a security, but not for the purposes of they obtaining one for themselves, but just for example risk assessment of a company. I need to know if their assets have securities on them, even though I'm not going to obtain one for myself.
Yes. So if you're an unsecured creditor, one of the bases on which you may be prepared to lend to the company unsecured is understanding what the extent of the secured credit is. Okay, I understand that.
But then the danger is there are transactions where you don't necessarily have third parties. So if you think it's void or initial, then you're not protecting anyone because probably that company just has one creditor in that particular instance. So for me, I'd rather go with the priority ranking, but not void it because you may make it void and yet there's no other creditor. So what it goes away with.
So what you're really saying is that making it void is disproportionate or might be disproportionate to the issue.
I would say that making it void would be useful for a certain class of creditors. So if you're making it void against secured creditors, and to that extent it is void. But it's still enforceable against the company and it's still enforceable against unsecured creditors. So that's my understanding.
Right, okay, so a sort of a variation. There are obviously a variety of approaches to this. And English law takes a rather peculiar approach to this, it seems to me, although in practice it effectively makes them void. It does it in a very roundabout way. Let me just get a view from you on two possibilities. I'm going to give you two stark alternatives. There may be various places you'd prefer to be in the middle of this, but you're going to have to come down one side or the other, at one end or the other of this particular spectrum. One view would be that the failure to register should affect the priority of the security interest. In other words, you would rank behind any later registered interest, but it would not affect the validity of the security interest in an insolvency or against the debtor generally. That's one view. The other view is that the registration may well be a priority point, but failure to register would render the security void in an insolvency of the debtor and thereby protect the unsecured creditors as well as other secured creditors. So the question then, would you go with just priority or would you go with voidness? Hands up those who would go just priority. Hands up those who would go voidness. Yeah, just priority wins actually by quite a substantial margin, which is very interesting. I have to say my view, for what it's worth, is that if you have a system which does not make the transaction void, which does not make the security interest, the proprietary right, void, then I can't see the point of having a registration system unless it's purely a priority one. And I can see the advantages of that, but it seems to me that just dealing with the priority point does not deal with the informational issue here, because when you go back to it, the great man himself, William Ewart Gladstone, one should always go back to William Ewart Gladstone, it seems to me. His great idea, it seems to me, of company law was that the trade-off of the ability to create a registered company and ultimately to have limited liability. The trade-off for that was information. People needed to be aware of what was going on. And I would see this in a similar light. I would see the trade-off from the ability to be able to create a security interest easily over all the assets of the company. The trade-off I would see there is I need to tell people about it, and if I don't tell people about it, I shouldn't be entitled to it. But what is very interesting is that the majority of you, quite a significant majority, just don't accept that. Your view would be actually it should work as a priority system. It doesn't need to work to benefit anyone else. So I find that very, very interesting. And again, it just shows how very strongly held and different views there are in this area. There are no rights or wrongs. So that's creation. Priorities was the next issue, and I don't want to spend very long on priorities because, frankly, it's a day in itself, more than a day in itself. But you have made one very valid point, it seems to me. Those of you who went for registration as a priority point, what you've said is that you think that the registration of the security interest should be a priority point vis-a-vis other secured creditors, at least other secured creditors who can register. And so one valid point I think to make is that any system of secured transactions should have a principle in it which ranks security interests by date of registration, not necessarily by date of creation. And under English law, as you know, we have that in relation to the asset registry, so land, ships, aircraft, certain types of intellectual property. We don't have it in relation to the company's registry. There's a lot to be said, I think, for applying it to the company's registry, but as yet that hasn't been done. But I don't want to get into the details of priorities for two reasons. First of all, because it's too difficult to cover in the amount of time that we've got. And secondly, frankly, it's not really terribly important. Now, you should cover your ears up when I say that. But actually, when you think of the number of cases on priorities that there have been over the last 50 years, there have been very few of them. Issues just don't arise very often in relation to priorities. That's not to say that we shouldn't have a sensible rule of priorities. Of course we should. But it is to say that it's not the burning issue, I think, talked about around the tables of those who deal with secured transactions in practice. So let's move on to something which is much more important in practice, which is enforcement and insolvency. Now, where do you start with enforcement and insolvency? Well, I suppose the starting point is when you should be able to enforce. Some systems restrict a creditor from being able to enforce security until a certain amount of time has been given to the debtor. So in other words, if you validly make demand on the debtor to pay and the debtor doesn't pay, there are some legal systems which say, well, you can't go ahead and enforce your security straight away. You've got to give a period of time before you are able to enforce your security. Do any of you come from jurisdictions that have systems like that?
I think so. I'm not entirely sure if it's Belgium.
In Belgium, I'm sure you probably do, I suspect. A number of civil law jurisdictions do. Some common law jurisdictions. Is there anyone here from Canada? I think you have a system whereby the debtor is given time to pay, at least in certain circumstances. The Canadian Supreme Court, I think, has by case law, created a principle that basically gives the debtor time to go away and try and refinance, at least in some cases, before the creditor can pull put the company into some sort of enforcement process. So there are jurisdictions which do that. English law is quite the opposite. English law says as soon as the ink is dry on the demand and you've delivered it, then you can enforce. The only thing you have to do is to give the debtor the time to go and get the money out of the bank, which even in these days of inefficient banking services is within 24 hours. And if you don't have the money in the bank, tough. So you've got two different approaches there. One is the debtor lives and dies by the document, and if the document says you will pay and you don't pay, then the creditor can enforce. The other one is to override that by statutory in civil law jurisdictions or case law in some common law jurisdictions, rules which say that you've got to give the creditor, the debtor, a period of time within which to pay, which can extend from anything from a few days to a month to a reasonable time. And I just want to get a view from people on which of those two you think is better. Who would give the debtor, the creditor, the ability to enforce once the debtor had not paid? Hands up, who would give him the instant right to enforce? Anyone? A few, very few. Who would give the debtor time to pay? Most of you. Now that's interesting too. Can I just ask one of you who would give the debtor time to pay? Why?
Perhaps it increases the possibility of recovery because the debtor actually has time to go about looking for finance and be able to get it.
And that's a very interesting point, because what you're saying is that it would increase the prospects of recovery. And I've absolutely no doubt, and every secured lender will agree with this, that the last thing you want to do, if you're a secured lender, is to enforce your security. Absolutely the last thing, because you know that you will lose money if you do so. What you want to do in practice is to keep the borrower going in order to enable the business to continue, for assets to be sold on a going concern basis where you get more value for them, and allow it to carry on in that sort of way. So I've absolutely no doubt you're right to say that you're more likely to get more value back if you don't enforce than if you do. But there comes a time when the secured creditor says, I've given you the time, I've done what I can, my legal rights under the document are to enforce. And then the question is, would you then give the debtor a further period of time?
I don't know how long are we looking at? I mean, are we looking at 30 days or something more?
How long would you like?
Conventionally, or in practice, you usually give a 30-day notice period, I guess, to a debtor to say that please pay within this much time or we'll enforce the securities. So I think 30 days would be fine.
Okay.
But then I think it's depending on the jurisdiction. I'm from Nigeria, and I'm not the first one to in Nigeria. We have these two distinctions between when the right becomes exercisable and when it becomes due. And that's probably because in Nigeria, most debts are given for overvalued security interest. And because the creditor has been exercised the right of foreclosure, the court knows that what you've learned, this property you're going to sell or foreclose, is way higher than what you've learned. So there's this right given to the debtor up to 3 months before the decree becomes absolute, and then you can foreclose. And the debtor has no further right. So maybe you have to swap the position of where the asset is overvalued more than the loan itself.
Yes.
It becomes a valid point to allow the debtor some time to raise the money.
I could totally see that, where the asset is worth substantially more than the debt. Then I can see different issues come into play. I mean, whether that should give rise to a different result is another matter, but I can certainly see that raises other issues where that happens. I've never, just shows, doesn't it really, I've never been in a situation where the value of my assets is more than the value of the liabilities that are being secured. So happy days if that was so. So we've got, I think the vast majority of you would give the debtor time to pay. The interesting thing in practice, I think, is that it's often envisaged that the little play that's being played out when a company is in financial difficulties is that on the one hand, you've got the secured lenders very keen to enforce their security and requiring the debtor to comply with the terms of what he's signed up to. And on the other hand, you've got the directors of the company pleading on their knees for the banks to give the company more time to pay. I've never ever been in that situation in my life. The situation I have been in many times, often acting for the borrower, sometimes acting for the lender, is that the lenders are desperate to avoid an insolvency process for exactly the reasons you described, because they know that an insolvency process will reduce the value of the assets overnight very substantially. So the banks are very keen not to enforce, but very often you get the borrower's directors saying, I want you to enforce. And the reason they're saying that is because the directors are concerned about personal liability for, in England, wrongful trading. It's a similar concept in most other jurisdictions. If you carry on allowing the company to trade when there's no reasonable prospect of avoiding insolvent liquidation, then the directors can be personally liable for all the debts of the company. Directors don't like that. They might lose their houses. And so my experience is that in most of these cases, it is the banks pleading with the company to carry on trading, and it's the company saying, no, I'm not going to carry on trading because I'm worried about my director's personal liability. So I suspect even if you had a rule, a 30-day rule, whatever it may be, I'm not sure it would actually really be needed in most cases.
But wouldn't happen, on the other hand, that having, for example, a 30-day rule makes loans more expensive? Because the creditor now, it has the time to recover the money, will always be thinking about counting the 30 extra days, even if you are going to make use of them, so the interest rates are going to be higher.
Well, certainly the point you've made is a very good one, because what you're saying is that it might increase the cost of the financing. And one of the things which seems to me to be true from personal experience is that the reason why secured lenders are very happy to, not happy is the wrong word, but prepared to sit on their hands and not enforce their security and try and get a consensual deal being done here. The reason they do that, the reason they go into workouts, is because they are comfortable that they can enforce their security at the drop of a hat if it needs to be done. So I do think there is probably something in that point. Yeah. So we've got when you can enforce, and there are sort of views there about whether you should be able to enforce straight away or not. You've then got the question of how you enforce. And I suppose that there are probably two main types of process that one would expect to find in most legal systems. One is a court-based system. In other words, in order to enforce your security, you have to go and see a judge, and the judge will do what's necessary to balance the interests of the debtor and the creditor. That's very much a civil law way of things. The other way is the common law approach, which is to say that security can be enforced by the creditor without going to a judge, either by going into possession of and then selling the assets concerned, or more likely by appointing an insolvency practitioner who used to be called a receiver and is now called an administrator, but does exactly the same thing, in order to enforce the security for you. Those, I think, then are the two views. One view would be you need a judge to hold the ring to ensure that the debtor is treated fairly, and the creditor also is treated fairly, but everyone is before the judge and the judge will decide. That's true of a lot of civil law jurisdictions. It's very common in common law jurisdictions like the United States, for instance, when you're into a Chapter 11 or something like that. The alternative idea is you allow the creditor to go off and enforce the security himself, but you then impose duties on the person enforcing the security, whether it's the creditor himself or someone on his behalf, like a receiver or administrator. You impose duties on them as to what they should do. So the first question, I think, is, do you involve the judge? Simple question, do you involve the judge? Hands up who says yes. Who think you should involve the judge in an enforcement process? 1, 2, 1. Okay. Who wouldn't? Who would? 2, 3? Who wouldn't? Sorry. Hands up who wouldn't involve a judge? Right. More of you. Did you say you would involve a judge? No, why?
I suppose there's a risk if it's every creditor for himself acting unrestrainedly on his official rights.
Yep.
There's a risk that it might turn into a race to strip the assets of the company.
Yep.
And as a result,
Yep.
everyone would in fact receive less than the otherwise would.
Yeah. So there's just a race to the finish unless you involve a judge. I do see that. What about those who take the view that you shouldn't involve a judge? Anyone prepared to say why?
Also, in my jurisdiction, usually the judge is
Yes.
there, but I would love to have a more flexible system because in most of the cases it could be enough to impose a duty on the creditor to sell for example, the asset for a fair market value because it is in the interest of creditor and the interest of debtor.
Mm-hmm.
So, and if there is some margin, then the creditor could be, for example, liable, or it could be the loss of the creditor because he has not made it in good faith. So the system could work perfectly because when you have a judge, you simply make this process too lengthy, and the judges themselves, they do not take very active part. They might not take very active part in the enforcement. Anyway, they will appoint another person, for example, a court executor, who will be doing the same thing as a creditor. And the problem is that this executor could be not so interested in selling the property as the most expensive value because it's not his business generally. So when we have a creditor who is more interested in getting more money, so the system could work better.
I mean, that's interesting coming from someone who's in your jurisdiction, as you say, you need judges to do these things. There is a concern that they're not necessarily the right people to do it. I certainly think English judges would not regard themselves as being the right people to do this job. It's a business job. My view, for what it's worth, is that the best people to do the job are insolvency accountants. When you've got good insolvency accountants who have to pass exams, both to be chartered accountants and also to be insolvency practitioners, and who have practical experience of doing what they're doing, then the system works very well, provided that, and this is absolutely crucial, provided that you have a system which requires them to act properly and reasonably in the circumstances. And then, of course, it's a question of weighing up the interests of the debtor and the creditor. Because what the creditor wants is to get repaid quickly, as you said. What the debtor wants is to get the maximum value out of the assets because he hopes that he may have an equity of redemption. And there is a tension between those two. The creditor also wants to get the best price, but actually he wants to get repaid, and so he doesn't often want to have to wait too long. And so where the tension comes normally in practice is the creditor says, I'm going to sell now, and the debtor says, well, if you wait for 6 months, then things might improve and you might get a better price. And the real question is, should the creditor have to wait 6 months? Or however long it is that the debtor wants the creditor to wait. And the way English law deals with that, and I think it's a fair compromise, is to say that the creditor has the absolute right to decide when to sell, but when he does sell, he's got to get the best price he can at the time. That seems to me to be a fair compromise between the rights of the creditor to get repaid and the rights of the debtor to get a fair price for the asset. Now, not everyone would agree with that approach, but that's certainly the approach the English courts adopt. But certainly every legal system will need some rule which imposes a duty on the creditor in enforcing the security to act properly. English law has created some problems in the past with that, but Raphael, were you going to throw in?
In relation to your personal view on as to whether the creditor should be able to sell to themselves or an enterprise, because under English law they can.
Yes.
They're just subject to slightly more onerous duties, but not it's not an absolute bar. Do you think that there's scope for just banning it?
Just banning. So, I mean, this is a very important point in practice that Raphael has raised, which is, should it be possible for the creditor to be able to sell the assets to an associated company? And as you say, under English law, he can. Should it be totally banned? I actually think we have quite a strong rule, and we may disagree on the strength of the rule. When I'm advising a creditor who wants to sell to an associated company, and it does happen occasionally where there's not much of a market, what I say is you've got to go out and you've got to get two valuations of the business or the assets, whatever it is that you're selling, from two competent people who know what they're doing, who can express a sensible view on what the valuation is. So you get two valuations, and then I say you pay more than the higher of the two valuations. And my view is if you do that, you have satisfied your duties under the law. Now, you may rightly say that is perhaps more than you might need to do under the law, but certainly that would be in practice what a secure creditor would do, I think, in order to enforce. Now, is that wrong to be able to do that? Well, I could see you might say it is, but there are circumstances where if there are no other buyers, then frankly you might just have to buy it in yourself. Now, one way you could do that, I suppose, is to have an auction and to buy it in at the auction if nobody goes above the reserve. As long as the reserve is at the right level, that would be a perfectly proper thing to do, I think. Very often in practice, I think you get better prices by private agreement than you do by auction. So whether that's a good idea. So I suppose I'm coming around to thinking it's probably, the system we have is probably just about okay, but I can see that it has its problems.
The only adjustment that I would suggest would be to force the creditor to go to court.
Yes, you could certainly force the creditor to go to court, and I can see that. That may be one possibility. Whether you'd actually get greater value there, I don't know, but I suppose it would concentrate people's minds. That's the point, isn't it? Yeah, I can see that. So you've got a variety of issues around how the enforcement process should work between going to court and not going to court. I think most people took the view that you shouldn't have to go to court. The real issue in practice comes if the debtor goes into insolvency proceedings. And I suppose the question there is whether there should be some sort of moratorium or stay on the ability of the creditor to enforce in circumstances where there's an insolvency process. And most jurisdictions, I suppose, do have a principle which says that when the debtor has gone into an insolvency process, at least a process which is concerned with the rescue of the business, so administration, Chapter 11, Sauvegarde in France, those sorts of things, that in those situations where there's a chance of saving the business, the creditor ought to be prevented from enforcing its security, because if it were to enforce its security prematurely, that might damage the ability of the insolvency officer to be able to sell the business as a going concern. That's the idea. Don't know it. Does anyone have a view on that? If you're a secured creditor, should you be able to sell, excuse me, come what may, or should there be a limit on your ability to do so in an insolvency process? Be interested in just a show of hands. Who says yes, you should be limited in an insolvency process? Hands up. Who says no, you shouldn't? Very few. Why would you say no, you shouldn't?
Well, I think that the right to sell, because I think that the creditor is of course very interested in returning the cash, for example, the principal of the loan, and so it might be sometimes more favorable for the creditor to have this security and to use it for the purposes. So I think that there might be cases when this right should be limited, the right to sell should be limited.
Okay.
If it is more favorable for the creditor.
Right, okay.
So I suppose that limiting the right to sell in insolvency case goes back to the feeling of the security in the first instance. Because total security is really important when the company is insolvent and not when it's solvent. It can meet its loan obligations, then I don't need to call on the security. If it can't meet the obligation any longer, then I should be able to call on that security to meet my own, possibly back-to-back obligations on that particular loan. So I wouldn't think there should be limitations.
Right. I mean, that's interesting. I mean, I think it's often assumed that it's a given that in a where you've got an insolvency type of process which is intended to save the business of the company, it's often assumed to be a given that there should be a restriction on the secured creditor's powers. And I think most people here probably would accept that, but not everyone would do so. And I think it probably isn't a given. I think it's probably something which, generally speaking, is done in legal systems, but it's certainly not necessarily the case that just because there's an insolvency process in force which is trying to save the business, that should necessarily prevent the creditor from enforcing. But there are a lot of jurisdictions where that happens.
What about the system of legal preferences in case we're not trying to sell the business but dissolve it? For example, the former employees of the company, should we let the creditor enforce the security if it's, for example, the only asset available and the former employees haven't been paid?
So where employees haven't been paid, should the secured creditor be able to sell? Well, of course, the way some systems deal with that is to give, I mean, there are various ways you can deal with that, aren't there? One is to say the state will step in and protect the employees, and a lot of systems, including in the UK, have a system whereby the state will step in, at least to a certain extent. Some systems will give the employees priority even over some types of secured creditor. So in England, as you know, an employee as a preferential creditor will take priority over a floating chargee, which creates very odd results in practice, but nevertheless it does give some protection to the employee. I mean, I suppose the question is, to what extent should you be protecting the rights of the employee? And at the end of the day, where the business is sold, the advantage of a sale of a business, it's always seemed to me, is that, first of all, you get a higher price for it than you would on a breakup. And that benefits not only the creditor, but also the debtor, if there's a surplus. The other great value of selling the business is that it preserves the business and it preserves the employment in the business. And therefore, employees, not all of them, because some of them will be made redundant, but some employees will certainly benefit from that. And so it seems to me that anything which restricts the ability to do an easy sale of the business to a third party, when at least some of the employees will go across under the transfer of undertakings regulations, if anything prevents that from happening, it is actually going to affect adversely employees as well as everyone else, because the one thing you want is to preserve the business, it seems to me. And of course, that's the other thing which there are very big differences on in relation to the way in which we deal with insolvencies, there are two approaches to this. One is to preserve the company, and the other one is to preserve the business. If you go to the United States, for instance, what they're concerned about doing by putting a company into Chapter 11 proceedings is to save the company. The company that goes into Chapter 11 comes out of Chapter 11 at the end of the day. And of course, the only way that you can make an insolvent company solvent is to reduce its liabilities by forcing the creditors to accept less than they're entitled to. So that's what would happen in a Chapter 11. The approach in the UK is completely different, of course. The approach here would be, frankly, we're not interested in the company. It's just a number. What we're interested in is the business. And the best way to save a business is to sell it. Because you've got this bunch of dunderheads who are the directors of the company which has gone into insolvency proceedings, who clearly don't know what they're doing because they've allowed the company to go into insolvency proceedings. So let's get it out of their hands, into the hands of someone who actually can carry it on successfully. So the best way to do that is for an administrator or a receiver to package up the business, sell it for the best price he can to a purchaser, the cash comes into the company to pay off the creditors, and the business sails off into the sunset with its employees and its business outside the threat of insolvency, if you like. Those are the two models. They're both aimed at the same thing, but they do it in a very different way. So what we've covered so far is most of what I wanted to cover. We're going to finish at 12:30, by the way, for any of you who are wondering how long I'm going to go on for. So it's only another 20 minutes, I promise you. What we've covered so far is what would make a good security system. And what I now want to do is just to spend a bit of time talking to you about what we've gone through in England over the last, I was going to say 20 years, it's probably longer than that, in terms of the reform process. And hopefully some of what we have discussed over the last hour and 10 minutes is relevant to this question of what we're doing now. There are a lot of people who think that we don't have a good system of secured transactions in England. The most important person who thinks that we don't have a good system of secured transactions in England is Sir Roy Good, in the sense that he has, to my certain knowledge for the last 40 years, been arguing that what we should do is to replace wholesale our law of secured transactions and to adopt Article 9 of the US Uniform Commercial Code. And the pleas to do that have been increased over recent years because over 10 years ago, New Zealand adopted a PPSA, Personal Property Security Act, and in the last 2 or 3 years, Australia has done likewise. And the Canadian provinces have for a very long time had personal property security legislation as well. So large swathes of the common law world have gone the way of Article 9. And that increases the plea, if you like, for England to follow suit. And in a sense, what has happened over the last 15 or so years has been to test that premise that it will be a good idea to adopt a Personal Property Security Act. The reason, let me come back in a moment to the reason why people think it's a good idea, but let me just sort of sketch in the history of it, how it all works in practice. In the late 1990s, the government, through what was then the Department of Trade and Industry, was planning to update the Companies Act. It had been updated in the 1980s, and the idea was that it should be updated in the early 2000s. And our Companies Act contains, as you know, the rules relating to the registration of charges. In fact, have you just been doing registration? Yeah. So you know that they are set out in the Companies Act. And therefore, when the department was looking at the reform of company law, they were necessarily looking at the reform of registration of charges. And initially they took the view that we just simply needed to update the registration rules, bring them into the 21st century, but by and large keep them in the same style as they had been since they were formulated in 1900. But then there was pressure from various parts to do a more widespread review of secured transactions, not just to deal with the registration of charges, but to look at security interest more widely, and in particular to see whether we ought to adopt a Personal Property Security Act along the lines of those in the United States, Canada, and New Zealand. At that stage, Australia didn't have one. That led to the Law Commission being involved in the process, and Hugh Beale at the Law Commission then took on the role of putting forward a proposal to change quite radically our process of secured transactions law. And the Law Commission put out 3 papers in the early 2000s, all of which are very well worth reading. An awful lot of work was put into that by a very small body of people, and they're all very well worth reading. And they started off by proposing that England simply adopted a Personal Property Security Act along the lines of that in Saskatchewan, because the Saskatchewan PPSA was thought to be the most up-to-date of the Canadian ones. And so there was a lot of toing and froing and discussion about that. And ultimately, the proposal was not taken forward by the department. After about 4 or 5 years, having consulted on the proposed changes, the department decided that they wouldn't go ahead with the proposals. And that meant that we would just have the old Companies Act, which was then enacted in 2006. And as you know, because I think you've just been doing this, in April last year, the law was changed in order to do the updating of the registration process, which had first been mooted back in the 1990s. So in 2013, we then got our new registration process, which has streamlined, in my view, and actually it helps the registration process, what we've now got, and it works, I think, very well in practice. So what we've had is, you can see it's a bit like an arc, really. You start off with just a few proposals to tinker with the registration system. You then get this big proposal from the Law Commission, which then gets smaller and smaller until ultimately the government decides not to proceed with it. And then you get this little change to the registration system. So we've had sort of 15 years during which there's been an awful lot of talk about the reform of the secured transaction system, but actually very little happening in practice except for welcome changes and simplifications to the registration system. And I suppose the question is why we haven't done anything. Now, if you were to ask Roy Good why nothing has happened, I think he would probably tell you, if you asked him in a quiet room anyway, he would say it's all the fault of the practitioners who have prevented this change from taking place. And I like to think he's right on that, actually, in the sense that there was a great deal of hostility to the proposals to change what we had. Now, of course, the problem with these sorts of things is the debate very largely divided down into academics on one side and practitioners on the other, which was unfortunate, but that's actually the way it developed. And so you got, in a sense, sort of sniping from one side to the other, the practitioners saying that the academics were trying to come up with a system which wouldn't work as well as our system worked in practice, and the academics saying that the practitioners simply didn't want change and that they knew how the current system worked, and it wasn't really in their interest to change it for something else. And there's a degree of truth, of course, in both of those statements. So it's certainly not the totality of the story. And what I want to do is just to explain very briefly why the practitioners took the view they did, that they didn't want an introduction of a PPSA. And there were really two limbs to it. The first limb was that it was actually thought that the system in England works quite well in practice, subject to one or two changes which ought to be made, that you can create an equitable charge over anything, including future assets. You can take a debenture over all the present and future assets of a company. You can register that security, which means that third parties will become aware of it. So you have solved the problem of creation by saying it's easy to create, but it's transparent. So in other words, it's only valid if you create security and you register it. It's not generally valid otherwise. You can enforce your security very easily because your security document will contain provisions which allow you to do so. There are rules which protect the debtor, such as the rule that when you sell, the creditor has got to get the best price reasonably obtainable at the time he sells. The priority rules, it was generally recognised, are a mess. But there were 2 points which were made. One was that in practice there are very few cases where that has proved to be an issue, which is not to say it shouldn't be changed, but simply that it's not the prime concern of practitioners. And secondly, that what we needed was a root and branch change to priority rules over personal property generally, rather than trying to deal with this issue solely in the context of secured transactions. Because if you deal with secured transactions, you don't deal with the whole picture. Better, it was thought, to deal with the whole picture. And then when you came to it, the real issue which everybody was worried about in practice was nothing to do with the law of security. The real problem that we all have in practice with the law of secured transactions is a problem caused by insolvency law. It's not a problem caused by the law of secured transactions at all. It's the problem that in a liquidation or administration of a company, certain creditors get paid ahead of floating charge assets, but not ahead of fixed charge assets. So preferential creditors, the unsecured creditors' lifeboat, the administrator's expenses, they all get paid ahead of floating charge assets, but not ahead of fixed charge assets. And that requires us, when we're structuring transactions, to do our best to try and shoehorn transactions so that they become fixed charges rather than floating charges. And frankly, it's not always possible to do that. And the problem that most practitioners have with the current law is that the law is drawing a distinction between fixed and floating charges, which is frankly artificial, and which doesn't help the process of creating a sensible and practical law of security. And if you did away with the distinction which insolvency law draws between fixed and floating charges, you would solve at a stroke the main problem that we have. And the only way you can do that is by reforming the insolvency law, because the issue comes in the Insolvency Act. It's not a part of the law of secured transactions. So where we got to was, actually, the one thing we really want to change is an issue of insolvency law, not an issue of secured transactions law. So frankly, why are we bothering to change? So that was the first part of the equation, if you like, that there was no point in changing. The other part of it was that there was a deep dislike, and there still is a deep dislike amongst English practitioners, rightly or wrongly, to the idea that one should register something which is not a security interest. And the way that Article 9 works and the other PPSA systems work is that they treat, sometimes for some purposes, sometimes for all purposes, transactions which are not secured transactions as if they were secured transactions. So if I lease you goods, I'm not actually the owner of the goods anymore. I'm simply a person with a security interest in them. And the general view of commercial lawyers in practice, certainly those that I have spoken to over these many years, is that they can't actually see why the law should recharacterise what the parties have done in that way. If I want to be the owner of goods and lease them to you, why shouldn't I be able to do so? Why should the law turn that into a security interest when it clearly, legally, isn't a security interest? So there were these two parts of the equation. One was we've got a system that works pretty well, and the one thing that doesn't work is insolvency law. That needs to be fixed. And the other is actually we don't really like the PPSA system insofar as what it does is to treat transactions which are not secured transactions as if they were. And for that reason, there was hostility to the process. Now, where we are now, very briefly, because I've got a couple of minutes and then I'll throw it open for questions. Where we are now is that there are two bodies around at the moment who are looking at the reform of secured transactions. One is the Secured Transactions Working Group, I think it's called something like that, which Roy Good established and which Louise Gullifer of Oxford University now is now the director of. And they are looking to bring in a Personal Property Security Act in the next few years. The other is a working party of the Financial Law Committee of the City of London Law Society, and I'm chairing that working party, which recognises that there are changes that need to be made to secured transactions law, And what we're doing is we've put out a couple of papers which are on the website of the City of London Law Society. The most recent one came out a couple of weeks ago. What we're doing is we are looking at those areas of the law which we think are in need of reform and seeing if there is a consensus for change. So rather than looking to bring in a PPSA, what we're trying to do is to say what's wrong and let's see if we can fix what's wrong. Now, I think I've probably said enough, so let me stop there. But if anyone's got any questions, I'm very happy to take them.
What's, I don't know much about insolvency in the UK, so it might be my mistake. What's the reason for the distinction between the treatment of the fixed charges and the floating charges?
It's historical. Everything in English law, of course, is historical, as you know. And you can't understand current English law without knowing how it developed, which of course is always a problem for those who come from overseas. It's a problem for us as well, I should say. The historical reason is that around the turn of the 20th century, there was a concern that when a company granted a floating charge over all of its assets, the lenders would come in and take all the assets, and the employees would not get paid. It's your point, actually. And so legislation was passed, which was effectively intended to assist employees and to say that employees who are preferential creditors were entitled, along with the other preferential creditors, to take priority over this security over all the assets of the company. And what that became in law was, if you've got a floating charge, the preferential creditors will take priority, but if you've got a fixed charge, not. And therefore we spend a huge amount of time in practice trying to draw a line between fixed charges and floating charges, because it's very important as to what will happen. So it's historical. Does any others have any questions? I think I probably... Yes?
Can you please explain Article 9 again, what it does?
What it does, Article 9, well, then I can do that in under about half an hour, but let me give you the 1 minute version. What Article 9 does is it broadly treats transactions which have the same economic effect as a secured transaction, as if they were secured transactions. So the idea is, if I lease you goods, and it's a finance lease, so in other words, I lease them for the useful period of the property, and you pay me a rental, which equates with the purchase price of the asset plus interest, then what we are doing, although legally I am leasing you the goods, I'm the owner, you're the lessee, in economic terms, I'm a secured creditor and you're the owner. That's what Article 9 is doing. So it's saying that if a transaction has the same economic effect as a secured transaction, then you'll treat it as if it were a secured transaction. And that's just anathema to most English lawyers, I'm afraid. Any other questions? I don't know whether Raphael or Sarah want to add anything, but
I'd just like to thank you for sharing your insights into secure transactions and the whole law reform process. I think it's fascinating to be able to hear about the dynamic. So thanks very much. Thanks to you guys as well for great questions and comments. So let's just show our appreciation for Richard's.